Hello and welcome to the Minimum Competence episode for Monday, March 24th, 2025. I'm your host for today, Andrew Leahy, a tax technology attorney from New Jersey. On today's episode, Paul Weiss's Trump deal fallout, 23andMe's bankruptcy filing, a judge rebuking Trump lawyers, and a unique Clearview AI privacy settlement. Let's remember, courage is resistance to fear, mastery of fear, not absence of fear, and read today's legal news. On this day in legal history, March 24th, 1661, William Leddra was executed in Boston, becoming the last Quaker in the American colonies to be put to death solely for his religious beliefs. Leddra, a devout Quaker, had previously been banished from Massachusetts under the colony's anti-Quaker laws, but returned in defiance of the order. His return led to his arrest, imprisonment in harsh conditions through the winter, and eventual execution by hanging on Boston Common. His death marked the culmination of a brutal period of religious persecution in Puritan-controlled Massachusetts, where Quakers were seen as heretical threats to civil and religious order. Between 1659 and 1661, 4 Quakers, Marmaduke Stephenson, William Robinson, Mary Dyer, and William Leddra, were executed under laws banning Quakers from the colony. Their trials and punishments drew condemnation from other colonies and even from England. Leddra's hanging, in particular, caught the attention of King Charles II, who soon after issued a royal order halting capital punishment for religious dissent in Massachusetts. This effectively ended the execution of Quakers in the colonies. The persecution stemmed from Puritan authorities' intolerance of dissent and fear of Quaker evangelism, which rejected formal clergy and embraced equality, pacifism, and direct spiritual experience. Quakers continued to face fines, whippings, and imprisonment, but the death penalty was no longer enforced. Leddra's martyrdom, like that of his fellow friends, became a symbol of religious freedom's cost and the struggle for tolerance in early America. His execution helped galvanize early opposition to theocratic rule and contributed to evolving colonial attitudes towards religious liberty. Paul Weiss chairman Brad Karp alleged in a firm-wide email that rival law firms attempted to take advantage of the firm's vulnerability following a March 14th executive order from President Donald Trump. The order directed federal agencies to sever contracts with Paul Weiss clients, prompting the firm to negotiate a deal with Trump rather than pursue litigation. Karp expressed disappointment that instead of receiving support, competitors tried to poach both clients and attorneys during the turmoil. The deal Paul Weiss struck included backing off diversity, equity, and inclusion initiatives and committing $40 million to pro bono work aligned with Trump administration priorities. Karp stressed that the administration is not selecting or approving the firm's matters. He acknowledged internal backlash and intense emotions over the firm's course of action, but maintained that litigation would have likely jeopardized the firm's future, even with a legal victory. Perkins Coie, targeted by a similar March 6th order, has chosen to sue and has already lost clients as a result. On March 21st, Trump issued an additional executive order directing Attorney General Pam Bondi to sanction attorneys and firms pursuing what the administration deems frivolous or vexatious litigation against the government. 23andMe Holding Co. has filed Chapter 11 bankruptcy in the U.S. Bankruptcy Court for the Eastern District of Missouri as it seeks to restructure and pursue a sale of the business. Despite financial challenges, the company plans to keep operating during the court-supervised process. The move is intended to help reduce costs, address legal and lease obligations, and stabilize operations. Once valued at $3.5 billion after going public in 2021, the DNA testing company has since struggled financially. Court filings list $277.4 million in assets and $214.7 million in liabilities. It secured up to $35 million in debtor-in-possession financing from JMB Capital Partners to support its operations during the bankruptcy. Co-founder Ann Wojcicki, who attempted unsuccessfully to take the company private earlier this month, has stepped down as CEO, but will remain on the board. Joe Selsavage has been named interim CEO. The board's special committee chair, Mark Jensen, expressed hope that the bankruptcy process will allow 23andMe to address its challenges more effectively. If you have a 23andMe account and it is holding your DNA, now would probably be a good time to delete both. At a recent hearing, U.S. District Judge James Boasberg criticized Trump administration lawyers for being intemperate and disrespectful in filings related to a case blocking the deportation of alleged Venezuelan gang members. The administration used the rarely invoked 1798 Alien Enemies Act to justify removing alleged members of Tren de Aragua without immigration court orders. Boasberg issued a 14-day freeze on those deportations, questioning the administration's interpretation of the law and whether the individuals had any real opportunity to challenge their designation as gang members. The administration filed documents accusing Boasberg of, quote, a judicial fishing expedition, prompting his public rebuke. Boasberg emphasized the importance of professional conduct in court and asked the Justice Department to explain by Tuesday whether it had violated his order by allowing 2 deportation flights to land in El Salvador after his ruling. Though Trump has said he would not defy court orders, the situation has raised constitutional concerns about executive overreach. Some deportees were reportedly refused by El Salvador's government for not fitting the criteria or being the wrong nationality or gender. Lawyers for the migrants argue the administration's reliance on the Alien Enemies Act could lead to broad and discriminatory applications. A U.S. federal judge in Chicago has approved a highly unusual class action settlement against facial recognition firm Clearview AI that doesn't include an immediate cash payout for affected individuals. Instead, under the agreement, class members, estimated to number between 65,000 and 125,000, may receive a 23% equity stake in the company. This could eventually translate into monetary compensation if Clearview is sold, merges, or goes public. The lawsuit accused Clearview of violating Illinois' Biometric Information Privacy Act, or BIPA, by scraping billions of facial images from the internet and using them without consent. Clearview denied any wrongdoing. U.S. District Judge Sharon Johnson Coleman called the settlement novel but fair, emphasizing that the equity share isn't speculative given the company's estimated valuation of up to $225 million. Based on that figure, the fund could reach $51.75 million. As an alternative to equity, a court-appointed official may require Clearview to pay 17% of its post-settlement revenue in cash by 2027. The deal also drew criticism from 22 states and D.C., which argued that the plaintiff's attorney's fees, nearly 40% of the settlement value, were excessive. Coleman defended the fees, noting that such awards are typical in the Seventh Circuit. The judge further noted that continuing the litigation would be complex, costly, and time-consuming, justifying the settlement's structure. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and can leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, clothes make the person. Naked people have little or no influence on society.